my client was walking his dog. Like, he was walking his dog on a well-recognized trail. This trail happens to go behind the houses between the greenbelt.
Welcome to Rebel Chaser. This clip is about a PPO, a greenbelt, a dog bite, and a woman who thinks people are peeping in her windows from the greenbelt. I don't know how that works, but let me know what you think.
We'll start with the matter of Noah Murray, Caitlin Bailey, and David and Lisa Tolbert.
Morning again, Your Honor. Thank you.
Mr. Huxford, good morning. You can take either table, is fine. And Mr. Tolbert, I'll need you to stand, and Mr. Murray and Ms. Bailey, if you'll both all three of you raise your right hands, please. Swear that testimony in this case will be the truth, the whole truth, and nothing but the truth.
Yes.
Yes.
Thank you.
Good morning, Your Honor.
Good morning. All right, so I'm familiar with the case because I've read the pleadings.
Certainly.
And I've read all the attached statements.
If it pleases the court, I would just like to make a record with respect to preliminary issues regarding evidentiary issues and or service issues. I was served via email, which is fine. We had agreed to that, and service of email with respect to the latest filing by the petitioner on June 15th. I know that the court is willing and likely to give a lot of latitude to pro se litigants with respect to getting a record before the court. I don't know if any of the witnesses that they provided declarations for in their exhibit packet are present here today, but I would object to the admission of any of those statements and declarations provided to the court from those three individuals on the grounds that they are not properly sworn declarations, nor do they contain any sort of language indicating that these were sworn statements under penalty of perjury. They do not comport with signature requirements with respect to sworn declarations for the court. Further, they were served on me Thursday prior to the beginning of a holiday weekend, which does not comport with service requirements in Thurston County under the 632 local rules. With respect to their statements, they're here to testify. I really don't have any, I would object to the declarations being admitted as evidence, but given the service issues, given the lack of any sort of declaratory statement that these are sworn statements, I don't think it's appropriate for the court to consider the declarations of witnesses that are not here. I know my client doesn't have a Sixth Amendment confrontation right in this proceeding, given the nature of the proceeding. However, I think that rule is instructive and important with respect to the court considering evidence that is ultimately hearsay above and beyond the declaratory issues. So we would urge the court to strike those from the record. Thank you.
Thank you. We'll note the objection. As I've said, I've read everything that's been filed, so I am familiar with the declarations that have been filed. And it's the court's policy generally to consider the evidence submitted by the parties. And I understand the objection and I can weigh the weight I will give that evidence.
That's all I'm asking, Your Honor. Thank you.
All right. Thank you. Okay. So, having reviewed the evidence in this case, we essentially have two components to it. One is what occurred on May 13th with the dogs, and that's one issue. And then probably the bigger issue is the Greenbelt access, which is an interesting issue. I do note that there appears documents apparently with the assessor's office indicate that residents of what is it, Newhall? Is that what's the?
We live in Wilderness, and the other neighborhood is Newcastle, Your Honor.
Wilderness and Newcastle. Yes.
Newcastle. Thank you. That the residents of Newcastle don't have access to the Greenbelt, according to a document, theoretically, as I understand it. However, there has been a long history of use by residents of both neighborhoods, and apparently the neighborhood associations are attempting to try to come up with some understanding as to how that works. So that's my understanding of that issue. So I want to let the parties know I'm aware of the varying opinions about the rights to access the greenbelt. But I will also tell the parties this court does not have the authority to decide that issue. If the parties can't resolve it, and I don't know, I don't know whether an association can speak on behalf of individual property owners or whether they have rights that the association can't bargain away. I don't know. That's going to be up to the parties to figure that out. I would encourage, perhaps, if the parties want to avoid having to go to Superior Court and hire lawyers and try to get a quiet title action, that they may consider using the Thurston County Dispute Resolution Center to see if they can come up with a mutually agreeable solution for the parties. To me, that makes a lot of sense, given what I've read from everybody who all believes that they're right. So those situations are hard for the parties to come to agreement, but if they can get a third party involved, it may be helpful. So that would be my thought on the issue of who has legal possessory rights to access the greenbelt. So I understand that's an issue, and I understand it plays out for Mr. Murray and Ms. Bailey, believing that Mr. Tolbert's daily walks with his dog lead them to believe that he is looking at them, that he is invading their privacy. I do see that from the photos that there is a fence that is in some early stage of construction, at least as of the last photos that I saw. And so they have some concern about people walking the greenbelt looking into their backyard. And then this apparently became an issue on the 13th of May when Mr. Tolbert was apparently bitten as two dogs had a conversation. So that's where we're at. I'll give Mr. Murray and or Ms. Bailey a chance to add anything you want to add, understanding that I've read your statements in full, and I've read the statements of everybody who submitted them on both sides. So I'll go to the petitioners first. Do you have anything else you want to add?
Regarding Mr. Huxford's issue with timeliness, we would just like to report that.
Okay, you don't need to address that.
Okay.
Just factually, do you have anything else you would like to add?
I think we feel confident that we wrote everything out in our statements, Your Honor.
Okay. And Mr. Huxford, does Mr. Tolbert have anything else he would like to add?
I don't believe that there's any additional record that we'd like to make with respect to testimony. I have a argument outline prepared to discuss some of the legal issues raised by the court.
Okay. Thank you. All right. I'll give Mr. Huxford an opportunity to make his argument. So I'll let Mr. Murray and or Ms. Bailey, one of you can choose to be the lawyer in this case and give me your argument, which isn't adding new facts. It's just arguing why you believe you should get the order. So one of you, go ahead.
Yeah, like I said, I think everything was kind of outlined in our statements. I don't feel that we should have to deal with people driving by our home or walking behind our home and threatening us with, various statements, saying they're going to bring a weapon to our home or threatening us and telling us they're law enforcement, they're attorneys, so we need to watch out. We just want to be able to, use our backyard freely and not feel threatened by the individual.
Thank you. Mr. Huxford.
Thank you, Your Honor. I think it goes without saying today that we are asking the court to dismiss the petition against Mr. Tolbert in relationship to the fact that the court is extremely familiar with this point. We did file, and I will again just reiterate that we filed a motion to realign the parties. I know that it's within the court's discretion to do so. I think it's our argument, in addition to dismissal, that also the behavior as offered by the petitioner themselves in the video they provided this court speaks to the aggression and harassment of my own client with respect to his use of the green belt, as opposed to him harassing anyone. With respect to the law, the black letter of the law expressly, I think it's very important that the court really focus on what conduct actually took place and whether or not that conduct meets the statutory definition of harassment in this particular instance, specifically a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, harasses, or is detrimental. I mean, I don't even think that the petitioner can get over that hump, frankly, if I'm being honest. What we're talking about is, I think it's very clear there's a property issue here that this court is not properly before the court, and that this court cannot address in the context of this particular legal vehicle. My client was walking his dog. He was walking his dog on a well-recognized trail. This trail happens to go behind the houses between the green belt. I think that it's very clear from the testimony and the record that's been presented by the petitioner that there's some conjecture about whether that's okay or not, and whether or not both HOAs recognize that this trail has been in existence, that it connects with a much larger trail system in LBA Park. And I don't understand how one state, Mr. Tolbert was a neighbor of theirs, how his conduct in walking on a trail that's not on their property. And I think that's another important point here. How is him walking his dog designed to alarm, annoy, harass, or intimidate them in any sort of way? He's passing by. We have a green stand with houses on both sides. I don't think it's unreasonable. I mean, they've made allegations and attached nefarious intent to him looking around while walking his dog in the green belt. I don't think that there's anything in the record to support a position or a factual narrative in which Mr. Tolbert is standing in their backyard, peering into their window. He's passing through and walking by under, if not legitimate authority or legitimate purpose, at least color of law, based on his understanding from the previous homeowner that this trail was accessible and that they regularly used it. The petitioner in their video during the alleged altercation that took place acknowledges that kids use the green belt frequently. There are multiple witnesses statements from other neighbors in the green belt that also provide us with context as to the understanding between these two neighborhoods, regardless of what the plats say and regardless of what the assessor's documents say. I believe that it's widely recognized, as evidenced by both HOA presidents acknowledging this in the email thread where this incident was reported to the HOA presidents, that this trail has been there, it's been there for years, and that it's been accessible from both neighborhoods. So with respect to that in and of itself, I think that there's really no argument here that Mr. Tolbert walking his dog, maybe it does make them uncomfortable, but the idea that that behavior was designed to annoy, alarm, and harass, like purposefully and intentionally, I think that fails as a matter of we've already kind of dovetailed the legitimate and lawful purpose aspect of that onto that argument as well. I think that, again, at worst, he was acting under color of law, but I think that my client had a good faith belief based on representations from the HOA presidents, representations from his neighbors, representations from the other homeowners in the community and the person he brought the home from, that he was completely legitimate in walking his dog there daily. I also don't think that this meets the course of conduct arm of the statute either. I think we've already addressed most of those issues. Finally, I think that the third component and the third element of harassment and unlawful harassment that needs to be addressed and considered by this court is which would cause a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress. It is clear to me from the video submitted by the petitioner that my client certainly comes to confront them about what had happened. It's certainly he, I think, was within his rights after just being injured. Whether or not he was bit by his own dog or their dog is kind of irrelevant. It doesn't matter. This dog charged his dog. He defended himself and defended his dog. If their argument is that an off-leash dog can just at will bolt out of its yard.
My
bite
dog
another-
wasn't off leash. My dog was not off leash, sir.
Okay, remember, I've read all the facts, so I'll give you another chance, Ms. Bailey, so hold on.
Again, I think what's important to understand is that once it was recognized and the petitioners have acknowledged themselves that they recognize that this was a neighbor, at what point does it seem reasonable that an objectively reasonable person would be alarmed by a neighbor walking on a trail recognized by both neighborhoods with his dog as a person with nefarious intent? I'm assuming, given my other work in the criminal defense field and also other anti-harassment protection order field, that there are any number of individuals who are not authorized to walk that trail that probably regularly walk that trail out of LBA. The fact that they recognized that he was a neighbor, that he went and had a conversation, or that they had a conversation about him being a neighbor, kind of strikes the reasonableness of Miss Bailey and Mr. Murray's fears that he's up to anything or that this would cause any substantial emotional distress. Normally, I would expect in a situation like this, the neighbors to talk to each other and get to know each other instead of putting up no trespassing signs on a trail that isn't their property, yelling fuck off or get the fuck out of here to my client.
Your wife yelled that at me. His wife yelled that at me.
Ms. Bailey, don't interrupt, please.
So this emotional distress that they have petitioned the court with and argued is reasonable, I don't think, as a matter of law, stands the objective reasonable test, nor do I think that they've proven with sufficient evidentiary support that they are actually experiencing any substantial emotional distress. The petitioners also submitted a dog that allegedly shows their dog injured and limping as a result of the kicks that they say that my client issued to the dog when defending his person and his other dog. That's not what that video shows. It's not what the video shows at all. So this idea that they're worried for their dog's safety, that they're worried for their own safety is hyperbolic and hyperbole. I think a final important inconsistency in their own statements to point out, since the court has read the record to date and is prepared to at least consider those statements with proper weight, is they allege that there's this nefarious gun violence threat lingering in the background and that their neighbors told them that they heard my client in his backyard unobserved behind his fence talking to his son about that. Okay, so both of those witnesses also provided statements. What they both don't mention is any threat of a firearm or any threat of Mr. Tolbert making a threat of a firearm against them. So I think that fails just from a credibility standpoint, because I don't think they can substantiate that allegation. Listen, my client is a disabled military veteran. He is a corrections officer. His wife is a biologist, I believe, or a scientist. Like, at no point has my client set out to harass anyone. If at most their best argument is that he drove by their house, that was specifically designed to find out what house number he needed to report this to animal services, because there was an animal services issue about an out of control, unruly dog that is biting people in the neighborhood. Law enforcement contacted them. Mr. Murray had an aggressive confrontation with law enforcement. Animal control contacted them. They told them in no under certain terms, based on the animal control report we provided to the court, that they weren't going to abide by a quarantine and that it was Mr. Tolbert that was in the wrong here and that their dog didn't bite anybody. So they have put themselves in a position to, contradict county officials, to frustrate county officials in doing their job. Where is the substantial emotional distress, Your Honor? Substantial emotional distress is not typically evidenced, in my opinion, by people having aggressive confrontations with their neighbors, then having aggressive confrontations with law enforcement, then having aggressive confrontations with animal control, when all of those public officials are just trying to do their job. And we have Mr. Tolbert trying to make sure that, he has a civil claim for damages if he really wants here, because he was attacked by his neighbor's dog. The idea that this dog was just defending its territory and that that's an acceptable, reasonable argument is a red herring. Listen, I would encourage the court to see through the inconsistencies in their statement. I would encourage the court to recognize that this is not the proper vehicle to resolve this dispute, as the court said at the very beginning of this hearing. And I would encourage the court very strongly to dismiss this petition as what it is, which is frivolous. And finally, we would ask the court and request that the court provide us with at least a temporary harassment order so we can consider whether or not we would like to move forward with this vehicle or another civil vehicle to address the claims that Mr. Tolbert has. Thank you.
Thank you. All right, Ms. Bailey, now it's your turn. And remember, I've read all the statements. I did read the statement of Ms. Tolbert indicating what she said, so I'm aware of that.
Thank you, Your Honor. I don't think the issue here is somebody walking behind our home and using a trail. That was never the issue. The issue is what he chose to do after the fact, which was driving by our home, not once to get our address, but back and forth by our home multiple times, choosing to stop his car and yell out the window multiple times, which was witnessed by our neighbor. If we want to talk about lying in statements, in his statement, David Tolbert stated that my dog was outside at that point, which simply is not true. Noah was up on a ladder fixing a light on the front of our home, and David drove by back and forth 4 times on Mother's Day, yelling out his window, while myself and my dog were inside of our home. My issue with him walking on the trail and looking on my windows, I understand that, peeping isn't harassment, but I've asked the individual to stop looking in my windows. He stated he can do what he wants. He can walk on the trail when he wants. We have no issue with people freely using that trail or freely walking in LBA woods. My issue is that he does it at early hours in the morning and late at night, hours at which LBA Park is not open. And then, the fact that Andrea and Todd came to our home and were worried about our safety because they heard statements made about himself and his son showing up to our home with an AR-47. I think regardless of if that's hearsay, it's substantiated, and I shouldn't have to fear that someone is going to come to my home with a weapon over walking on a trail. Their attorney wants to state that this is something that should be handled person to person, which I totally agree. But in my opinion, it escalated beyond that point to where I felt unsafe and I felt the need to, file an anti-harassment order. I would have loved to have it handled outside of court, but I didn't feel that was something that was going to happen. And that's, why we filed this anti-harassment order. I think we've additionally taken steps, to rectify the situation for ourselves by building a fence and, buying curtains and doing different things like that. We've additionally talked to our HOA. I know there is a land use issue. But ultimately, the land is owned by Wilderness HOA, regardless of what anybody wants to say. Myself and my partner, as well as David, moved into the neighborhood at the same time. So them saying that the trail has been used for years, 20, 40 years, our neighborhood was built 20 years before Newcastle was built. And the Greenbelt is meant to be, an in-between space and access for utilities. It was never meant to be a trail. I would like to also point out that this supposed trail only goes from David Tolbert's backyard into LBA Woods. It doesn't go the entire length of the neighborhood. When we moved in, there's a handful of people that use it. That's no problem at all. My issue is just with the harassment that has occurred. I'd like to additionally point out that I have not driven by his home. I have not gone to his home. I don't know what color his house is. I don't, know what car he drives, except for the fact that Noah saw him drive by our home. Everything that has occurred on our property. I have never, seeked out going to his place of residence to try to talk to him and try to harass him. He's only come to my residence and done that. And, his point that we harassed law enforcement or were aggressive is just unsubstantiated. Me asking animal control to please leave and telling them that I'm not going to sign any papers is totally within my right, because they were choosing to only listen to what David had to say and were unwilling to take down my written statement and take down my story. So at that point that they were unwilling to hear my side of the story, I asked them to leave my property.
Thank you.
Thank you, Your Honor.
So, I've heard the arguments that I kind of expected to hear, having reviewed the evidence that had been submitted. As I said, I can't resolve the property issue.
Correct. And we've gone to our HOA and that will be
Right.
resolved.
Yeah,
Okay.
we're here to.
That's one I can't resolve. When I hear some of these cases, I just put myself in situations of the property owners, and I own some property, and what's it like if people walk back behind my backyard? It's woods. I have kids. all that stuff. So is it unusual that somebody would make use of a path through a wooded area without even checking, as long as they don't think it's on somebody else's private property, where they're intruding in a yard? Yeah, sure. People run through, walk through, that's not unexpected. And heck, I grew up that way. So just from taking the law out of it, that doesn't seem to be so unusual to me. This obviously came to a head when Mr. Murray and Ms. Bailey's dog broke free of its collar and advanced on Mr. Tolbert and his dog, and Mr. Tolbert ended up with a bite on his finger, however that happened. I think both parties felt like it wouldn't have happened if the other party wasn't there. And of course, there's some logic to that, which is it wouldn't have happened if another party wasn't there, but it did happen. And then there was a reaction to that. Everybody sort of took a step back and started creating some defense around their own actions and blaming others. I don't think this is worthy of a protection order. I understand why there was a request. I will disagree with Mr. Huxford in that Mr. Murray and Ms. Bailey, as Ms. Bailey points out, they felt threatened enough that they felt obligated to file a petition for an order. And to me, that's a big step for somebody to take. And that's a pretty good sign in and of itself that there's a level of concern that people have that they now have to try to get the legal system involved in resolving an issue that causes them concern. And I'm going to say this: I'm not going to grant the order. I'll dismiss the current order. But I'm going to, reiterate that I encourage the parties for resolution of these long-term to think about using an organization like the Dispute Resolution Center, which, in fairness, I used to be a board member of, but I am a huge fan of the work they do, and they appear in our court calendars on a regular basis to assist folks in mediating disputes, and they do an excellent job. But this may be bigger than that because it involves two homeowners associations. So I would encourage you to work through your homeowners association. But I'm going to expect going forward, Mr. Murray and Ms. Bailey have made clear to Mr. Tolbert their concern about any direct contact between Mr. Tolbert and them. And by the sole nature of having filed this petition, they're making a request that there be no contact, Mr. Tolbert, with them. So I don't have the authority to say whether you can or can't walk on the path, but should you choose to walk on the path and believing you have the right to do so, you'll make that decision. But you should in no way engage in any contact with Mr. Murray or Ms. Bailey. And to the extent that you do, and this continues, they have the right to come back and say, after we had this whole hearing, he continues to do whatever they, are going to assert you're doing, like driving by their residence or other things that they have that are concerns. So I would urge you not to do that. And same for Mr. Murray and Ms. Bailey. I urge you, if he's walking back behind your property, don't, you don't need to tell him you don't have the right to be back there or whatever it is. Everybody's working on that. Everybody knows there's an issue there. And apparently there are steps being taken to try to figure that one out. So I would urge you not to have any contact with Mr. Tolbert. And to the extent that either party can't abide by that and decides that they need to contact the other, it's going to be fairly good evidence that it's meant to be harassing and not problem solving, since we're here trying to solve this problem today. And either party could come in and make a request for protection of court at that time. But for today's purposes, I'm going to hope that, having aired these issues and both parties have heard fully what the other party's concerns are, that will be enough to have everybody take a step back and try to deal with this in a way that's a little different than how it happened this spring. All right. Thank you all.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. And I'll sign an order dismissing it, and we'll get copies to the parties.
So, what'd you think? I saw this as, there was a lot of maximizing or exaggerating and a lot of minimizing. So there was a little, there was a lot of both. And I think the judge made the right call. I think if she had any remorse for her dog biting him, it probably wouldn't have gotten that far. So anyway, that's my 2 cents. Let me know what you guys think.